With that, we will turn to the individual programs, the individual statutory amendments, focusing on the specific issues identified earlier. That is jail screening, personal recognizance bonds, and competency restoration. Let's turn to the first focus of these new procedures, additional procedures, which is changes to the screening program. Screening is already legislatively established under Article 1622 of the Code of Criminal Procedure. The primary change to focus on here is one related to timing. The initial appearance, sometimes called magistration, is to be undertaken within 48 hours of arrest. The existing statutory framework under Article 1622 had a reporting requirement under which notice was to be given to a magistrate of reasonable cause to believe that a defendant charged with a Class B misdemeanor or higher has a mental illness or an intellectual disability. The reporting requirement is already there, but focus on the time frame here. The current statutory time frame is 72 hours. The report has to occur within that 72-hour period, which is after the 48-hour window for magistration to occur. With that disconnect in mind, the statute has been amended effective September 1, 2017 to require that the notice of a possible mental health issue to be given to the magistrate within 12 hours so that it can be acted on within that initial window in which magistration is to occur. The statute slightly broadens the source of the notice. As written prior to September 1, 2017, the notice was to come from a sheriff. As revised, the statute requires notice from a sheriff or a municipal jailer having custody of a defendant, in recognition of the fact that in many circumstances, the initial contact, the initial arrest is not going to be only through a sheriff or only through a sheriff's department, but may well be through a municipal jail or a related entity. The point here is that there is no new requirement to collect information. The focus here is passing it along from the initial arrest to the magistration and doing it in a timely way that can be useful. If a magistrate determines that there is reasonable cause to believe that a defendant has a mental illness or is intellectually disabled, then the magistrate shall order the local mental health or intellectual disability and development authority or another qualified expert to collect information from the defendant and to provide a written assessment on a form approved by the Texas Correction Office on offenders with medical or mental impairments. An assessment is not always required. For example, an assessment is not required if, within the past year, the defendant already has been determined to have a mental illness or an intellectual disability. If a defendant refuses to submit to the information collection, then a magistrate can order the defendant to submit to an examination in a jail or in another place determined to be appropriate by the local authority for a period not to exceed 72 hours. This is another statutory change to streamline and tighten up the timing a little bit. Instead of 21 days, the time frame has been shifted to 72 hours. The written assessment must be provided not later than 96 hours after the order for a defendant who is in custody, or if the defendant has been released from custody, not later than 30 days after the order. Upon receipt of an assessment, the court that has responsibility for the case can undertake a number of options. The court can resume criminal proceedings and address release on personal bond if the defendant is being held in custody. The court can resume or initiate competency proceedings under Article 46B. The court can use the assessment in connection with punishment as part of a pre-sentence investigation or to set conditions for community supervision. The court also can refer the defendant to an appropriate specialty court if such a court is available. On the theory that the state needs solid data in order to understand whether defendants with mental illness are being addressed effectively, there's also a requirement to report. Magistrates will submit monthly reports to the Office of Court Administration regarding the number of written assessments that have been provided. That completes the overview of the new screening requirements. The next segment will focus on the availability of personal recognizance bonds for defendants with mental illness.